Madam President, on a separate subject, this bill, 3747, is a bill which is historic, 149 pages of it. The first 60 are pages that address prison reform. This bill in its entirety has been endorsed by the spectrum, by the political spectrum of America. I can't remember, and I say to Senator Grassley, I can't remember another bill that had this kind of support. Left and right, liberal, conservative, Republican, Democrat, it's all there supporting this legislation. To have a bill that Senator Grassley and I have worked on with Senator Lee and Senator Booker, I mean, that tells a story in and of itself, the four leaders on this legislation. But then to consider the fact that President Trump has endorsed it, that Vice President Pence has come to the Republican conference lunch saying he's behind it and urging the Republican caucus to support it as well, really speaks to the political bipartisanship that we rarely, if ever, have seen in Washington. The groups that are behind it are equally amazing. To have the support on an important criminal justice reform bill of the Fraternal Order of Police is a great starting point as far as I'm concerned. And then to have the leading prosecutors, the leading Criminal Prosecutors Association, join with the police really tells you that on the law enforcement side, we have the major leaguers. Then on the other side, incredibly, we have the American Civil Liberties Union supporting this and most of the major civil rights organizations. I think we've really struck a good point here where we have worked and compromised for 5 or 6 years to reach this moment. It's possible that as early as today, this bill will be up for us to vote on. But before we reach that point, there's a possibility of amendments that are going to be offered. 3 amendments, as we understand it, under the current procedure. And I would like to address generally the amendments that will be offered. Senator Cotton is the lead sponsor of these amendments, Senator Cotton of Arkansas. There are 3 amendments because Senator Cotton took his original amendment and literally divided it into 3 pieces, which is his right under the Senate Rules of Procedure. And I've taken a look at those, and a very close look, I might add, and I want to put on the record some facts which I hope members of the Senate on both sides will consider when the Cotton amendments come before us on the floor. One of the major elements in Senator Cotton's amendment here is notification of victims. In other words, if we're going to change the status of a person in federal prison to the point where they may be released early, Senator Cotton suggests that we must notify crime victims. It sounds reasonable on its face, and it is. In fact, it's so reasonable that we currently have a law that guarantees that. This Crime Victims' Rights Act is a federal statute. And under the Crime Victims' Rights Act, we say to criminal victims, you have the right to know if the person, the criminal defendant who perpetrated the crime against you is going to have a change in their status as a prisoner. And many other things we spell out here in about 10 different provisions giving rights to crime victims. This isn't the only guarantee of crime victims learning what might have what's happening to the criminal defendant who perpetrated the crime. Turns out the Bureau of Prisons does the same thing. They notify crime victims of change in status of the criminal defendant. What is the difference then? What is Senator Cotton trying to add to this? He's adding to it an element that is really worrisome, and I'm afraid he hasn't thought it through clearly. You see, under the Crime Victims Act, it's up to the crime victim to determine whether or not they want to be notified. It turns out that over the last 5 years, 10% of the crime victims, when given the offer of being notified about a change in status of the criminal defendant, 10% of them, about 160,000, have said, no, we don't want to be notified. We have consciously decided, don't notify us. Why? Why would a crime victim say, don't notify me? Well, there are myriad reasons. Consider the possibility that the victim is an infant or a child who's gone through a horrible experience involved in this crime. And the guardians or parents of that crime victim who is a child have decided that they don't want their child to be exposed to all this information about some criminal defendant for whatever reason. It could be as a result of psychological counseling. It could be that they don't want them to face re-traumatization of going through, reliving that horrible criminal experience. Think of an adult who decides as a crime victim, I want to put this behind me. I don't care to hear anything more about this. My life is going to go on in a separate track, and this is the past, and I want to look to the future. So a crime victim, even an adult, can decide, don't notify me. It's their decision. It's not a government decision. It's an individual decision. We give to crime victims the respect and the freedom to decide if they will be notified. Senator Cotton does not. Senator Cotton mandates notification, requires notification of the change in status. That's serious, and it could have a serious impact on someone who's already been victimized, forced into some horrible condition in their life, that they'd be forced again to revisit it when they do not want it, when they consciously do not want it. So what have the crime victims associations said about the Cotton Amendment? It's universal. They have said it's wrong, and they've said it in very explicit terms. Let me tell you one group that I think is important for us to consider: the Crime Survivors for Safety and Justice. We believe it is the leading, largest crime victims organization in America. Over 30,000 crime victims are part of this organization to stand up for the rights of those who've been victimized by crime. And what do they have to say about the Cotton Amendment that would force notification on people who do not want it? Here's what they say. A mandatory notification requirement is contrary to the victim-centered approach of avoiding re-traumatization. Current law and DOJ policy, Department of Justice policy, permit a victim to determine whether he or she wants notification of release. A mandate, the Cotton Amendment, a mandate like this requires notifications for those who may not want it and could trigger trauma for thousands of victims many years later after the crime. They go on to say, Bureau of Prisons data on the release date of any prisons is publicly available on the Bureau of Prisons website. Victim notification is already required by law if victims choose to receive the notice. The Crime Victims' Rights Act provides the right to timely notice of any release. They go on to say, victim notification already occurs through the Department of Justice's automated victim notification system if victims opt to receive the notice. This system is a partnership with the Bureau of Prisons, the FBI, U.S. Postal Inspection Service, and the United States Attorney's Office. It is a free computer-based system which provides victims with information on scheduled court events, the outcomes of events, custody status, and release dates. In other words, all of the information about the disposition of a criminal defendant is currently available online, easily acceptable by crime victims if they choose to receive it. 10% of them, 1 out of 10, say no. We don't want to receive it. Senator Cotton, in his amendment, does not respect that decision by 10% and says they will be required to receive it. That's not good for crime victims. It certainly violates the spirit of the Crime Victims' Rights Act, where we leave that decision when it comes to minors and even adult victims to the families affected. Why would we override that provision in the law? There's another group that's come forward. A woman by the name of Tricia Forbes. She's with the Texas-based Regional Training Manager for Crime Survivors for Safety and Justice. In the Hill newspaper, which was published this morning, she has a lengthy article opposing the Cotton amendments. Here's what she says, Cotton and Senator Kennedy claim they are trying to protect victims with an amendment to force the Federal Bureau of Prisons to notify victims of a crime when the perpetrator is being transferred to pre-release custody. But their real goal, according to her, is simply to delay, dilute, and derail the bill. The existing draft of the First Step Act, the bill which I referred to initially, was the result of careful bipartisan, bicameral negotiation. By adding their last-minute amendments, Cotton and Kennedy want nothing more than to break up the broad bipartisan coalition that has come together to support this bill. There's also a letter from Ann Seymour, who is a project director for fairness, dignity, and respect for crime victims and survivors. This letter, which she sent to all members of the Senate, says, "I write today to urge you to vote no on Senators Cotton and Kennedy's Victim Notification Amendment. It is clear that Congress can and must do more to support the needs and rights of crime victims and survivors. I'm disappointed that almost no elements of the First Step Act are tailored specifically to needs of victims. However," she says, "Senators Cotton and Kennedy's proposed amendments neither comply with best practices in trauma-informed victim services nor improve the bill." She closes by saying, "I urge you to vote no on Senators Cotton and Kennedy's amendments and encourage you to offer solutions better tailored to identify and address the needs of crime victims." So the crime victims groups have come forward and said the Cotton amendments would be harmful to crime victims. Those who wish to be notified have every right to be, and they are provided that notification under a statute and under existing policy of the Bureau of Prisons. Those who opt out and say, "I don't want to be notified," should be respected. We should not force this on them. And I encourage my friends, those who are considering this bill and discussing it with their staffs, look closely at what the crime victims organizations say about the Cotton amendments and understand that if we are going to be respectful of these people who have been victimized by crime, we have to vote no on those amendments. The second element, which has been raised by Senator Cotton in the amendments, relates to the crimes that are listed as making you ineligible for prison reform programs, for early release programs. Our bill is 60 pages long. More than 20 of those pages, more than a third of the bill, is filled with a list of over 60 different crimes, federal crimes, that we say if you've committed this crime, you are not eligible as a federal prisoner for the rehabilitation program in this bill. 60 different ones that we've added. Members would come up to us, to Senator Grassley, myself, Senator Booker, Senator Lee, and say, "We think you ought to add such and such crime." We'd take a careful look at it. And in most cases, we agreed to do it. Let me give you an example. Senator Ted Cruz, a conservative Republican from Texas, and I think he wears that label proudly, said he would consider voting for our bill if we would consider adding a number of crimes to the list that would be ineligible for that criminal defendant to ask for the help in this bill. We looked at it carefully. There were about 6 or 8 of these that we thought were acceptable. We asked if we could add those to the list, a list of already 60 crimes. Unfortunately, Senator Cotton objected. He did not want that added to the bill. Now it turns out he's going to argue in his amendment he wants part of the Cruz list to be added at this point. Well, we had a chance to do it, and it was a bipartisan measure, but he objected to our adding it. However, he has one provision in his amendment which goes far beyond Senator Cruz's list or the enumerated bills which we said make you ineligible. He has created a new category of crime. It's almost, I've read a lot of definitions over the years. It's really hard to follow what he's trying to achieve here, because what he has said is that in addition to the enumerated crimes which would make you ineligible, he adds the following: any offense that is not otherwise listed in this subsection for which the offender is sentenced to a term of imprisonment of more than 1 year and, quote, has as an element the use, attempted use, or threatened use of physical force against the person or property of another. I've never seen that definition. Physical force against the person or property of another. We went to the Sentencing Commission and said, how many crimes would that include? And they said it's impossible to calculate, but we think that at least 30,000 people would be ruled ineligible by those words that I've just read, who might otherwise be eligible for earlier release. So what he's come up with is his own definition of a criminal standard, one which we've never seen before. And he wants that to apply to this bill, which we've worked on for 6 years. So I would say when it comes to the Cotton amendments, members of the Senate really have a very clear and stark choice. They can support a bill which has been worked on a bipartisan basis and enjoys the support of police, prosecutors, and those groups which protect our constitutional rights, all together, right and left, supporting. They can support a bill that has bipartisan support here on the floor of colleagues and members who rarely come together, but we've come together on this bill because we found a good compromise. They can support a bill which has the support of survivors and criminal victims organizations, or they can vote for the Cotton amendments. And the Cotton amendments which are being offered, opposed by crime victims' rights groups across the board, by the leading crime victims' rights groups, supporting the Cotton amendment is basically saying to these crime victims, we're going to force this information on you, whether it's in the best interest of your family, whether you want it or not. That is not respectful of crime victims. And I hope my colleagues will join me in opposing the Cotton amendments.